Hi friends, hope you're fine and doing well. I welcome you once again to the lecture series titled as Law Simplified, wherein we have been making all possible endeavor to give you the conceptual clarity of the commonly used terms in law. Today's the topic of discussion is injunction. This is in fact the most important topic for all of us, not only the people who are into a practice. If I see from the litigant point of view, this is the most crucial task or the process which we need to understand, which we need to follow, and so that he could get his grievance redressed from the court of law. So now this remedy has been provided for many reasons, but before I get to the procedural aspect and the relevant provision, for the better clarity and understanding, I will be taking three live example, you can see, or the illustrations, like for the clear-cut understanding. Say you are a tenant paying rent regularly to your landlord. The landlord wants to let out his premises to somebody else because he is going to get a hike rent from the market. You are opposing and you want that although you could be charged an increased rate of rent, but you should not be dispossessed for many reasons. He hired some goons or the muscular persons who have been causing you tension, disturbance and the nuisance. Then you go to the court of law that, sir, the due process of law may kindly be followed in order to evict me, and he should be restrained to intervene into my peaceful possession. This is one illustration. Second is that there is a family, father, few sons, mother, wives of the sons and the kids living together. The father gets expired. The moment he passes away, one of the members is very tough in the family, now want to sell the property. Other co-sharer or the co-owner, they want that property should not be sold, and the tough guy should be restrained to sell the property to any third person. Fine. Third example, we take case that A and B. A enters into a contract with the B to sell his flat worth rupees 50 lakhs, receive a consideration as an earnest money to the extent of 10 lakh, and then agreed to execute the sale deed after 6 months from the day he received the earnest money. Now during the 6 months, price of the property escalates, and now he wished to sell it to some third person, not to the person with whom he executed an agreement to sell, but to some third person. Now the person who is a vendee, who agreed to purchase, is a sufferer. Now he goes to the court of law and say, sir, he should be restrained to alienate the property. Right. So three examples we discussed, my dear friends, for the reason to give you the broader view and the utmost clarity on the law of injunctions. Now injunctions are of two kinds, perpetual and temporary. Perpetual injunctions and temporary injunctions both are governed or regulated by specific relief act. Section 37 deals with the temporary injunction and 38 of the SRA deals with the permanent injunctions. Now you need to understand the meaning of these two. First you need to understand the meaning of injunction. See, it's a judicial order or a command given to do certain act, or a particular act, or to restrain somebody not to commit an act or omission. Right? Such a judicial command given to the defendant or the opponent with a view either to do something or not to do some act or omission. Right. Now what is the object of the injunction? As I discussed in the illustration, the court's utmost duty is to prevent the interest of the plaintiff and the subject matter which is in question before the court. Now, if there is a threat of invading your interest or the interest has already been evaded, I mean your civil rights have been affected largely by the act of omission of the others, then this becomes a duty, fundamental duty of the court to protect you. Now, suit, the decision in the suit, the decree, the ultimate crux, what we discussed in the last lecture, may take time, but till the time the subject matter should not be damaged or defeated, because ultimately it would amount to miscarriage of justice. To prevent the miscarriage, the court will have to intervene, and at any stage of the suit the injunctions could be granted. As we discussed in the last lecture that you have some civil rights. If the civil rights are likely to be infringed or violated because of any threat or injury by anybody, then you can come to the court of law, seek remedy or a relief that you should be protected, and court, after considering number of factors, the material produced and your contentions, may or may not grant you injunctions. But today we would broadly be discussing the concept of temporary injunction. Fine. In SRA, section 38 provides the condition wherein the perpetual injunctions could be granted, and 41 provides the conditions where it can be refused. Now, the question is temporary injunction. On what factor and parameter it should be granted, or what are the factors which court has to consider while deciding the application for the grant of injunction. See, commonly it is also known as stay, like you must have heard people discussing that we have got a stay in a case, like we have applied for the stay. The stay means the injunction by the court, by the judicial, or the order by the judicial process is called the stay. 2-3 more terms which we usually used, like ad interim stay and then status quo, these all are associated with the injunctions only. Now, Order 39 provides procedure for seeking the temporary injunction. Now, my dear friends, you have to understand it. A person who has been presiding over the court is to balance the interest of both the parties, and it is a very powerful job which requires an utmost intelligence, clarity, integrity, honesty, and number of other things. Without that, the justice could not be rendered. Fine. This is the most crucial job which a civil judge has to perform while considering the application and passing an appropriate order on the same. Fine. Now, this relief of temporary injunction, and temporary injunction means the injunction which is specified for some time or remains operative till the further order of the court. And during the pendency of the suit, it could be given at any stage, but for a limited period or till the court decides, till the time court decides. Now, it is an equitable and discretionary relief. The court has to act while considering the pain and anxiety and the suffering of the parties concerned, to act as a court of equity. The first and foremost principle of the equity court is that one who seeks equity must do equity. When the person should approach the court with a clean hand. He should not suppress the material fact from the court. His petition or his plaint should not be fake or the manipulative. He should state the fact very clearly, and then in that case he could be entitled. The second is the court while granting the ad interim, now you need to understand the ad interim as well, in the most emergent situation, either without hearing the other party or even if the defendant is present but he is not ready with the pleadings, then this stay could be granted. But at different occasions the Honorable Apex Court have issued the guidelines that it should be used, ad interim stay should be granted sparingly only in the cases where it is so warranted, so required, and again the discretion which is to be exercised, that should be exercised not arbitrarily but with the keeping in view the judicial principles in the mind. Now, in a Gujarat Bottling Company versus Coca-Cola 1995 Supreme Court further say there are 3 factors which are required to be satisfied, and which we usually, those who are in practice, once they draft an applications under Order 39 Rule 1 and 2, they mention prima facie case is made out in the favor of my client, there is a balance of convenience, and irreparable loss would be caused if the injunction is not granted. Now, these 3 things which you need to prove to the court of law, and these 3 factors which court has to consider while granting or withholding the injunction. Now, you need to understand the meaning of these 3 terms. When you say prima facie cases, does not mean that you have 100% case in your favor. It only means that the contention which you are going to raise in the court of law, the court of law should consider those contentions on merit, and the cause or the grievance should not be decided summarily. So, if court finds weight or substance in your contentions, then obviously you would be able to get the requisite relief from the court. Balance of convenience, if I say in simple words, the court has to make a comparative study of the pleading of both the parties, stand taken by both the parties. Now, herein court has to see that if while granting the injunction the more hardship and severe hardship is going to be caused to the other party, then it would be better to withhold, not to grant. So, the court has to see the pleadings and the contentions, has to hear the argument and accordingly decide after weighing the averments made by them. And third, the court which has to see is that no irreparable loss. Now, it could be in many ways, like if an irreparable loss is going to be caused by withholding or not granting, then court would weigh, decide, opine and ultimately give the conclusion. So, my dear friends, these are the 3 parameter factors, rather I would say, wherein the court has to consider, and this was in Gujarat Bottling Company versus Coca-Cola 1995 case. Now, ad interim I have already discussed. One more term which is used often, that is status quo. It means to preserve the matter, to preserve the subject matter in a status quo, means as it is, fine. So, it is another form of stay, but it is bit different from injunction. You could say the court only ordered that once it is passing a status quo order, it means the subject matter has been preserved by the court till further order or the finality of the case. Now, court is to take due care and caution while granting, especially while granting the ad interim relief. If possible, it would be safer, to give the short date only, and when the party finally comes, then on merit, on hearing, the stay should be granted. Fine. Now, we studied in the last lecture where there is a right, there is a remedy. So, whenever there would be an infringement of any right, anybody whose rights is being infringed, he can go into court of law and seek the relief. Right. Then Order 39 Rule 1 specify certain conditions where the temporary injunctions could be sought. Now, what are those conditions? If there is a property which is going to be damaged, wasted, or in danger, or it is likely to be alienated or sold, or there is a threat to the dispossession as I illustrated earlier, and if somebody is running away from fulfilling the contractual obligations, I mean there is a breach of contract is likely to take place, and due to that the injuries is likely to happen. In such like cases, the court can grant the injunction. And last but not the least, wherein the court opine that interest of justice so require. It is mentioned provided under Order 39 Rule 1, one of the I would say the condition in such like eventuality wherein the interest of justice is likely to be defeated, then court can intervene and grant injunction. So, I hope that I have been able to clarify see, it is a judicial process. To do or not to do certain things could be issued at any stage, temporarily during the pendency of the case, till further order, or till the time court specifies it, and perpetual it is after hearing of the case on merit when the final verdict is to be given, could be given. Or section 38 and 41 of this SRA, Specific Relief Act, deals with the perpetual, and 37 deals with the temporary, and Order 39 Rule 1 lays down the conditions wherein the provides the procedure also, and lays down the condition wherein the temporary injunctions could be sought. So, my dear friend, I think it is enough for today. See you in the next lecture. Thank you so much.